All right, looks like everyone's in the room. So good morning, everyone. My name is Brent Rubin, and I am a member of the Dallas Association of Young Lawyers Judiciary Committee. And I wanted to welcome everyone and tell you thank you for joining the final event of our virtual Coffee with the Court series that we're doing this summer. And this last event is with Chief Judge Owen from the Fifth Circuit. To start off, I wanted to thank the sponsors for this series. Our platinum sponsors for the series are Platt, Shima and Richmond, Kane, Russell, Coleman and Logan, Castle Law PC, Lyon Simmons, and Ryan Law Partners. Our gold sponsors are Aiken Gump, Strauss, Hauer and Feld, Bell, Nunley and Martin, Cobb, Martinez and Woodward, Greenberg, Traurig, and Thompson Knight. And our silver sponsor is Carrington Coleman. And our CLE credit code for this event is 174-090-342. And this event is for 1 hour of credit, and I believe you need to self-report that. I'm so thrilled to welcome our honored guest today, Chief Judge Priscilla Owen from the Fifth Circuit. Just a little bit about her. She's a native of Palacios, Texas, and a double Baylor graduate. She graduated cum laude with a Bachelor of Arts and also graduated cum laude from the law school at Baylor. And after she graduated, she got the highest score on the Texas bar exam. After Baylor, she joined Andrews and Kurth, where she made partner and focused a lot on oil and gas litigation. And in 1994, joined the Supreme Court of Texas. In 2005, she became a member of the Fifth Circuit. And just last year, she became the Fifth Circuit's Chief Judge. And on a more personal note, I had the honor of clerking for her a few years ago, and it was a tremendous experience, and she's been a really great mentor to me. So I'm really pleased to welcome her this morning. So without further ado, we have Chief Judge Owen.
Good morning. Thank you all for inviting me.
Oh, so happy to have you. And just a quick explanation of how this program is going to work. I'm going to more or less ask Judge Owen questions, and towards the last 15 minutes or so, we'll open it up for members of the audience to ask questions. So if you do have a question, there's a little Q&A box at the bottom of the Zoom. So type your questions in there, and hopefully we will have time to get to all of them. So to start out, Judge, once again, thanks so much for joining us. As an appellate judge, you are not in the courtroom every day. So I think a lot of us see what a trial level judge does on a day-to-day basis just from being in court, whereas we may see appellate judges at oral argument, where I think the Fifth Circuit sits about once a month. What does a day-to-day life look like for a judge in the Fifth Circuit?
Well, as you might imagine, there's a lot of reading, a lot of writing. Active judges sit on average 7 times a year in the 3-judge panel, and we usually have 20 cases on the docket. We're a pretty active in terms of caseload. We've got a pretty heavy caseload. So we get the briefs in about 6 weeks before the arguments. As you know, the law clerks do bench memos, but the judges start reading the briefs, start looking. The bench memos are circulated, well in advance of the argument. We read the bench memos. In the meantime, we're working on opinions from other earlier sittings. Then every single day we get motions and all sorts of things that come in electronically these days, including a lot of cases that are decided on what we call the summary calendar. The last time I looked, I think only about 17% of the cases that are filed in the Fifth Circuit that are decided on the merits are actually argued at oral argument. A lot of our cases are decided on what we call the summary calendar, and the judges read the briefs. Whoever's the initiating judge for that case either writes an opinion, or if it's a criminal case, most of the time we will have an opinion that the staff attorneys in New Orleans have prepared, and 99.9% of the time we can read that and sign off on it. But it does take time, and then, as I said, we get motions electronically just about every day that you have to deal with. So it can be a very sedentary job. You don't make yourself get up and move around occasionally, but just a lot of reading and writing and communicating with your colleagues in your law firms.
And you said that only 17% of cases get oral argument. How does the court decide what cases get oral argument?
We get the docket, as I said, it usually has about 20 cases on it. And it just takes one judge to say, I want to hear argument. So if somebody wants to hear argument in a case, it gets argued. But if all three judges agree that it's probably not going to be beneficial to have argument, then it will be decided on the briefs. And sometimes the parties themselves, we have in the briefing requirements, there's a section that asks each party to state whether they want oral argument or not. And it's frequently we'll get both parties saying, this can be decided on the briefs. It doesn't really merit argument. Because it's an expensive proposition to have your lawyer travel to New Orleans or wherever the arguments might be heard, typically New Orleans, and prepare for oral argument. So a lot of people, they think their case, again, it's just not the kind of case that they think argument will help. So, but you can look at the opinions we put out. I'm sorry, you can hear my dog. Shh, come here. And I'm sorry.
Oh, no.
Anyway, you can kind of see the cases that get arguments.
And where else?
All kinds of cases get arguments.
And where else besides New Orleans does the Fifth Circuit sit?
We sit in Houston. We sit in Fort Worth every now and then. We sit in Dallas every now and then. We do go to law schools occasionally. Usually, like once a year, we'll go to a law school. Whoever invites us, basically. And every 3 years, we go to Oxford, Mississippi. I've never had the pleasure of sitting in Oxford, but basically, we sit in New Orleans.
And you became chief judge last year. What are your responsibilities as chief judge versus when you were just a regular circuit judge?
It's really surprising of the extra matters that a chief judge gets. One thing I was unaware of until I actually became the chief is that in cases where it's a federal death penalty case, it's a death penalty eligible case, before the U.S. attorney can ask for the death penalty, there's a very long process that goes forward, and it's hundreds of thousands of dollars are spent funding it. Essentially, the defense team does their mitigation case up front and interviews witnesses and does mental health and all these kinds of issues, experts, and then they get to present to the Justice Department their case as to why they should not ask for the death penalty. So those budgets are huge, and they come to the chief judge. Of course, it's passed through a district court judge usually looks at it as well, and then we have a team of people in New Orleans who are experts that help give me advice on this. But it's time consuming, and there's more of them than you would imagine. And we get budgets. I get budgets in other death penalty cases that, including the death penalty cases that come from state habeas. And if certain cases are over a certain size, we get a certain dollar amounts, we get budgets set. So I have to approve all of that. I approve the CJA vouchers. That's the court-appointed attorneys in criminal cases in general. That's the bottom line, is I have to approve and sign off on all of those before they get paid. The judicial misconduct complaints, we get a lot of those, and 99.9% of them are frivolous, but they still require, we have a team of people again who, lots of these are handwritten, go through and write a memo to me and then prepare a public order, a draft public order, and a draft private order. So then I go back and look at all of that. I look at the complaint and the memo and the draft orders and have to sign off on those. So there are It just takes a lot of time. And then there's the random phone call that you get almost every day from a judge or someone, some issue. I'm sure I'm not remembering everything. A lot of administrative work.
And has your staff in chambers, do you get additional staff to help you out with that, or?
Yes, I get an additional staff member in addition to my judicial assistant and 4 law clerks. I hired a woman who is a lawyer to be an additional administrative assistant, but she does have a law degree and it's very helpful. And we've tried to divide it along the lines of what is case related versus administrative. And so she's in charge of the administrative side.
And how did you become the chief judge of the Fifth Circuit?
It's not by merit. It's totally statutory. It's set by statute. In my case, Chief Judge Stewart's term expired the last day of September of last year. And it was about 4 days before my 65th birthday. So by the statutory succession, I was the most senior active judge under age 65. So it fell on me.
In under the wire.
Just whatever. But also my term, normally the term is 7 years. But since I will turn 70 before the 7 years is up, my term will only be 5 years, assuming I make it that long. But
I think who's going to succeed you as chief judge?
Jennifer Elrod, Judge Elrod.
I wanted to talk for a few minutes about briefing on the Fifth Circuit, because so much of what you do is reading briefs submitted by the lawyers. I guess I'll just start off with a general question. What makes for a good appellate brief?
Someone who can synthesize the arguments and make them clear and not repetitive and not too argumentative, and can find the case law that is on point. That's the main thing. And also to be very, very accurate about what's in the record. And if you say the record says this, we require you to give a pinpoint cite. We go and look. Somebody does, and often it's me. And so hopefully you're candid about what the record says. Not everybody is, but a good brief is.
So either the judge or the clerks will be checking all of your record cites, so you want to make sure that they're as accurate as humanly possible.
We may not check all of them, but I will certainly. I just did this yesterday. Another judge had sent an opinion characterizing the evidence, and I thought, well, that sounds like arguments from a brief. So sure enough, I went and looked, and it was arguments from a brief. Then I dug down, went back to the district court's opinion, and found that what exhibits he had been referring to, and found those in the record, and they do not say what the lawyer said that they say. So that was myself, going into the record and finding it. So I do look on the when you get down to the critical evidence, I look.
Very important. And you mentioned that you don't want to see a brief be too argumentative. How do you strike the right balance between being a good advocate, zealously advocating for your client, and not going overboard?
Well, to me, the most effective briefs, adjectives really don't help your case that much. The most effective briefs are the ones that have good arguments. In other words, here is the law, and we have the facts to support that. And, just very straightforward. Here's our position. Here's what we say the law is, and here's what happened, or here's the contract, or whatever the issue is. It's just very straightforward and to the point. That's helpful, if we can get to the point.
And are there any common pitfalls or problems that you see in briefs that lawyers make fairly often?
Not really. Our briefing parameters are pretty set. You've got to do these sections, and most people follow the rules. And every now and then you get a brief that's a little too argumentative, or as I said, unfairly characterizes the record or what happened. But most of the time, the briefs are pretty straightforward. You probably remember they come all across the spectrum. Some briefs are really, really well done. Others not so much. And then there's a broad swath in the middle. I'm sure you recall. You read
Yes,
a lot of.
yes, that there certainly is a spectrum that I did see as a law clerk, with some of them being outstanding and others, requiring quite a bit more work just to get through, to try and figure out what they were arguing. I know one topic that comes up pretty frequently among appellate lawyers, which was really, I think, spurred in large part by Brian Garner, is where to put your citations. I know that you tend to put your citations when you write an opinion in the footnotes, but do you have a preference when lawyers are submitting briefs?
I do. I prefer the footnotes because if I do not do speaking footnotes, meaning I put only citations to the case and maybe with a parenthetical about what the case is about or the statute. But it's hard for me when I read a brief and they've got string cites. It breaks up the text, and it's just harder to follow for me. And I also, you can say the Court of Appeals from Texarkana or the Supreme Court from Louisiana, or identify the court during the course of in the text of the brief, so you don't have to look down at the footnote or look at a parenthetical to see what weight that authority should be given. It's just easier for me if the footnotes are dropped down, and the cites are in a footnote. But if you look at the court's opinions, I'm definitely in the minority on that. Most of our judges continue to put the citations and the string cites in the opinion. There are only a handful of us that drop it down to footnotes. And a lot of people use speaking footnotes on our court, particularly to respond to a dissent or, and I just don't do that, but a lot of people do.
And you mentioned that there's a difference of opinion on the court. Is there a way to know who's going to be on your panel while you're briefing it?
No, there's not. We don't sign the panels are not given the cases until 6 weeks before the arguments, and by that time all the briefing is complete, and it's just a random assignment to a panel. We don't know what we're getting. The lawyers don't know who the panel is. There's no way to know, so you just have to write to the court.
And one thing about the Fifth Circuit that is different than some appellate courts is, for record cites, there's a very particular form that practitioners need to use, right?
Yes.
And how does a practitioner find out how to use the form that the Fifth Circuit requires?
I would hope that that's prominently on our website. And and our clerk's office is very, very user-friendly, I think, at least. They go out of their way to help people if you are confused or you can't figure it out. One thing that our record cites are, if they're done properly, they're linked on our briefs. In other words, we're reading along on a brief. I read my briefs on my iPad or a laptop, and you can click on the record if it's properly done, and it takes you to the record, or your cases. They're hyperlinked, so it's really a useful tool for us to have links to Westlaw or the record using those hyperlinks.
And I know the Fifth Circuit software automatically creates cites to the links to the record. Does it also link to Westlaw as well, or is that something that lawyers need to add in themselves?
I really don't know. I don't know. I haven't written a brief in so long. But I thought there was a tool where it will hyperlink your brief for you on your software, on your laptop or your computer, whatever you're using. I don't really know, to be honest with you. I do know that recently the clerk's office, they have a way of checking. A lawyer can, without bothering the clerk's office, can go online and have kind of like a pre-check of their brief, and it will tell you if you complied with the briefing rules by and large. And if you haven't, it will tell you what the problems are, and you can correct it before you file your brief. I think that's up and running.
That's
I know that they were intending to have it up and running. I think it's out
yeah, that's really great to know. It's been a little while since I filed a brief in the Fifth Circuit, so I
there.
look
And
forward.
it's also a tool for sole practitioners and even pro se appellants. It will generate the form for you. Like,
Oh,
it will generate the sections, the required sections. So you just go in and fill it in, basically.
oh, wow,
The
that's
case.
great.
And again, they told me about all this in December, and I think it's up and running.
That's great. And then you mentioned it's okay to call the clerk's office with questions when you're a practitioner.
Yes. I mean, I would look on the website first, but if you have a question, just call the clerk's office. There, I mean, the feedback I get, at least from the public, is that they're very, very friendly and happy to answer questions. But I would start with the website in the rules. We have Fifth Circuit rules that pretty much track the federal rules, but give more information. So that it should all be there on our website of what the briefing rules are.
Yeah, there's a very helpful practitioner's guide on the website that I almost always, have up on my screen when I'm preparing a brief in the Fifth Circuit, which is really helpful. But in my experience, sometimes I do have to call the clerk, and as you said, they are always very, very nice and very happy to help.
I'm glad to hear that.
Kudos to
If they're
y'all.
not, let me know.
Kudos to y'all for having such great people to work
We
with.
do. We have a great staff. Our court clerk is he's very professional, he's a great guy. And he cares very much about the employees in the clerk's office. And it's a really good group of people. We're very, very lucky to have them.
That's great. And is that one of the things that you're responsible for, is hiring some of the higher level court employees?
I'm certainly involved. It's not solely up to me. We usually have a search committee of judges on our court that interview people. And I would be part of that. And then the committee votes and presents it to the court.
And one of the things that some of our members might be interested in hearing a little bit about is jobs that lawyers might be able to get at the Fifth Circuit. Well, they're I imagine a lot of people are familiar with the term law clerk positions, but what other jobs are there for lawyers, either early in their career or later on after they've gotten some experience with the Fifth Circuit?
Excuse me. Some of our judges have permanent law clerks, which means that it's someone who's been out in practice or done something else for a period of years, and then comes back and works with that judge, as the term implies, permanently. So the judge would have one permanent law clerk, and then depending on if they're senior or active, they would have 3 or maybe 1 or 2 other term law clerks. So that's a possibility. In New Orleans, we have approximately 55 staff attorneys who all have been, I don't remember the exact qualifications, but who've been out in practice for a while. And the staff attorney's office screens every criminal case that comes to the Fifth Circuit except the death penalty cases. So before a criminal case hits the judge's chambers, in more than half of them, the staff attorneys read the briefs and write a very detailed memo to the court, and with record cites. It summarizes each side's argument, has pinpoint record cites, and then does a separate independent analysis, of the law. And more than half the time, they draft a proposed opinion for the judges. And that's how, like I said, more than half of our criminal docket is decided on the summary calendar. But sometimes they look at a case and they say, we think this should go to argument. They won't write a memo. They'll just make the recommendation that it go on the argument calendar for the argument. So the staff attorneys also deal with all of our immigration cases, at least in the first instance, again, screening those. They deal with some of the pro se matters that we get. So those are positions that lawyers occupy. We also have I'm trying to think exactly what they call them. They started out doing the mediation side. They're lawyers. They do if parties want to have mediation at the appellate level, they're there to facilitate that. But their job description has grown over time. Those people also screen the judicial misconduct complaints. They're the ones that I mentioned earlier. Look at the complaint, write a memo to me, and make and have orders. And if it's a serious misconduct case, that's not treated that way. Obviously, they work very, very closely with the judge. In some cases, we appoint a committee to investigate, and they'll work very closely with that committee in investigating a judicial misconduct complaint. So those are the things immediately that come to mind of where we have lawyers at the Fifth Circuit who've had experience in other areas before they came to the Fifth Circuit.
And if someone's interested in one of those positions, would you find out about it on the Fifth Circuit's website?
Yes, it would be posted. And another thing that's not technically an employee, but we do from time to time appoint counsel in pro se cases. I've got one on the docket for September that I actually appointed, got counsel. He said this does need counsel. It's a significant case, significant issue, and it really would benefit everybody if it was argued by a lawyer, briefed and argued by a lawyer. So we have, you can sign up to be a volunteer on those kinds of cases, and we do have a few of those where we ask lawyers to pro bono represent somebody. It can get kind of tricky in criminal cases in particular, because you worry about a conflict of interest. If you just argue one issue, it may not be in the client's best interest in the long run to win on that issue, because if it's remanded, they might be facing a stiffer sentence. It's kind of tricky. But anyway, we try to work through those issues. But on the civil side, we do appoint counsel on occasion. So if you want to get the experience of briefing and arguing in the Fifth Circuit, that's a way to do it.
And are the appointments of counsel for these civil cases, is that different than the Criminal Justice Act appointments?
Yes, the CJA, those are paid. Those people are paid. But the civil cases, it's just pro bono.
And as a young lawyer who might be interested in getting more appellate experience, do you recommend either signing up for the pro bono program or the CJA or both?
The CJA, unless you have a criminal background, you probably shouldn't. You might not want to do that. That's pretty specific, pretty specialized. But certainly you might look into becoming a member of the Federal Bar Association. But we do have a list of people who volunteer to take a case that the clerk's office and our mediation people have, that you can get on that list.
And going back to briefs for just a second, you said a few moments ago that you read them either on your iPad or on your desk, on your computer. Mm-hmm. Are there things that someone writing a brief can do to make them easier to read on a screen?
Yeah, I've heard people talk about that. I'm really not an expert. It's not, to me, I don't see that it makes that much difference. In other words, the briefing is all, the rules are the rules about spacing and word length and all of that. So they look pretty uniform to me. And so I mainly read them on my iPad. And you can highlight and make notes, and and you don't have to carry around boxes of briefs like I did in the old days. You can have everything, including the record, if you want to put it on your iPad. You can have all of it right there.
You can travel to New Orleans with just the carry-on.
Well, not quite, but close.
And then another significant component besides the brief is oral argument. What helps you more to decide a case, or how do how does briefing versus oral argument help you decide a case if they do it in different ways?
I think if you ask most judges, they would say that argument does not change their minds in maybe 75 to 80% of the cases. I think it gives clarity to the judges. It helps might clarify certain things. I also think it's important for the parties to know that they've been heard and that someone has actually, really carefully read the briefs and the authorities, and they understand what the case is about, and everybody has a chance to put forward their positions. I think the best thing that an oral advocate can do is to listen to the judge's questions, because sometimes you get a judge who's just trying to say, I'm right, aren't I, because, but a lot of times a judge will signal to you where he or she has trouble. And for example, some judge might ask you, if you were going to write the opinion, how would you address this issue? But I think you need to listen to the judge's questions, and sometimes they're friendly questions, sometimes they're not so friendly, but that's your opportunity to try to address any concerns that the judge or the panel might have about your side of the case. So it should be an exchange. It should be a conversation. A lot of people get up there and they're just wed to their notes, and they consider a question, like, I'll answer it as quickly as I can and get back to my notes and get back to my prepared argument. And I think if they do that, they miss the opportunity to engage with the court and perhaps persuade on an issue that they didn't realize was an issue for a judge or the panel.
And I think every good oral advocate hopes that they can get up to the podium and answer every judge's question perfectly, but I think we've seen it sometimes with even, the most top-notch of advocates that they're unable to answer, a question. They just don't know the answer. Is it appropriate to submit follow-up briefing after oral argument?
Yes, but you have to ask the court's permission. I typically, if a lawyer can't answer the question, I just say, okay, why don't you submit a page or 2-page letter within the next 7 days, or whatever. But a lot of judges, if you don't ask permission, you say, Judge, I'm sorry, I don't have that at my fingertips. May I supplement with a page or 2 letter? If you don't do that, a lot of judges will have it stricken. If you just write in after argument, say, I didn't cite this authority in my brief, we just missed it. A lot of judges will say, no, that's not a proper use of a 28J letter. Rule 28J allows you to supplement after a case has been argued. If, for example, the Supreme Court were to decide a case or another circuit decided an issue after you had argued, that would be a legitimate use of 28J. But if it's not that, as I said, a lot of judges will say, no, we're striking it. I don't personally like to do that. I think the more information we have, the better, but not everybody looks at it that way. So if you can't find what you need to find right there and argue, say, Judge, may I please supplement post-argument? And most judges will say yes.
And if you wake up in the middle of the night after your oral argument and realize, oh shoot, I don't know how I felt about my answer to this question, or I think I had something to add, should you request permission to submit a 28J? Should you submit a 28J? What do you think is?
Well, if it's not truly a 28J, you can't wrap it up in a different package and say it is.
Mm-hmm.
I guess you can try, you say, may I have leave to supplement? But sometimes that's well received and sometimes it's not. It just depends on the particular presiding judge.
I guess you have to be thoughtful about it and really think about whether it is worth it and makes a big difference. Right. And when you're submitting a brief to the Fifth Circuit, as you mentioned, there's a place in the brief where you can request oral argument or tell the court that you don't think oral argument is necessary in the case. If you want oral argument, are there particular points that you should make as an advocate in that portion of the brief that'll really help you as a judge say, hey, I think this merits argument?
That statement is designed to be fairly short. And so you can say, I think argument would help because, if you can say it in a sentence or two. Some people, I think, misuse that section of the brief and make it a lot longer than it really needs to be. Generally speaking, if both sides ask for argument, they're going to get it. That's not true in every case, but if both sides want it and have a cogent reason, generally at least one judge is going to say, yeah, this should be argued. It's not guaranteed by any means. And sometimes, even though both sides say no oral argument, we might ask for it anyway. You know, I'm wondering about this as I'm thinking through a post-pandemic world. We might be more inclined to grant Zoom arguments in those cases where parties don't want argument, because at least it would say that save the travel time and cost. And they would get their day in court without incurring at least that piece of the expense of having their counsel have to go travel somewhere and spend the night. And I'm thinking of these things that we might talk about as a court once we're past all of this, that we might schedule it not during an argument week when we've got 20 cases on the docket. We might just say, let's have it on a Wednesday, 2 weeks after, whenever. And that might be a way to, if we think a case needs argument, to get it.
That would be really, really great, I guess, just to save, counsel and the parties.
Zoom is not as good as in person, but it's certainly adequate, I think.
Have you done Zoom arguments?
Yes.
Already? And any particular suggestions for someone arguing via Zoom versus an in-person argument?
I think you need to treat it just as if it were an in-person argument. In your demeanor, your back, what's in back of you, what you wear, how you respond to questions. I think you need to treat it just as if it were an in-person argument.
So be standing, have some sort of podium, and
I think it's helpful to stand.
Mm-hmm.
You don't have to have the podium on camera, but you don't have to stand, but make sure you're not slumping down, or I think it's easier to advocate when you're on your feet. That's why most lawyers want to stand when they have argument, because it helps you speak more forcefully. You're thinking on your feet, so to speak. But the first, Judge Stewart and I were the first two panels that had video arguments in April, I guess. And it was kind of rocky because we had not done it before. We're not using Zoom at that time. We used a different video platform. And some lawyers had really poor internet connections. Others did it in their bedroom with like interesting backgrounds, let's just put it that way. Someone had their cat in the back walking across the drain board, and it was just, but very quickly, advocates, I think, started talking to people who had done Zoom arguments a lot more, and I think that everybody caught up to speed pretty quickly. Our IT people work with the lawyers ahead of time for arguments to make sure that they pick a location where they have a strong internet connection. We had one of our court clerk during our arguments, the first ones I did in April. She was doing them from her home in New Orleans, and somebody cut the wire on their street, and she just went out, and she was gone for the rest of the day.
Oh, no.
So we had an IT person come in and be the court deputy in the middle of all of it. So, we've had some technical issues here and there, meaning the court as a whole, but by and large, they've gone pretty well, particularly once we got Zoom for government. That seems to be the best platform.
Okay. And does the court have a projection for when oral arguments in person might start again, or is that still?
We do not. That decision's right now is being made on a month-by-month basis. I just got a report yesterday from both the clerk's office and the circuit executive's office talking to their counterparts in all the other circuits. And so far, nobody's gone back yet. And they don't know what they're going to do about October yet. We're not having in-person September arguments, and we'll have to decide here in the next couple of weeks what we're going to do about October.
And so there's no in-person oral argument right now, and I think you mentioned earlier that you don't have to submit paper copies of briefs to the court.
Well, yes, you do, actually.
Oh, okay.
Some of our judges, even now, want paper copies. So the clerk's office will tell you, if you need them and how many. It's kind of on a case-by-case basis.
Any other significant changes that practitioners should know about in the Fifth Circuit in light of this whole horrible COVID situation?
Oh, no, I don't think so. I mean, if you get put on the calendar, the clerk's office is going to communicate with you about what to expect. We're going to have Zoom arguments, or is it going to be submitted on written questions? Is it going to be just submitted on the briefs? The clerk's office will be in communication with the lawyers. And like I said, we try to decide at least a month out so that everybody knows, yes, I need to be prepared for Zoom, or maybe not, or not. But, like every month, the clerk's office lawyers call, am I going to have to travel to New Orleans? If so, how do I file a motion for continuance? Most people do not want to travel for arguments right now. Would you be willing to travel for arguments?
If I had to do it for my client, I would probably load up the car and make the 8-hour drive to New Orleans, but I'd prefer to do it by Zoom at this point, I think.
I think that's the sentiment of most people. We've informally surveyed the frequent flyers in our court, and so far, by and large, everybody says we really don't want to come back yet. People are concerned about the travel and spending the night in a hotel, and where would you find food, and all of the issues.
And I don't think that when I was clerking for you, there was ever an oral argument submitted on written questions. Is that something that the court started doing more often now that COVID's happened?
Yes, we had a case with a lot of issues on it that we took in bank or en banc, and for the May sitting, we did not have in-person arguments. And so I came up with a schedule where the judges could ask a round of questions to the appellant, and then the appellee or both sides, and it was several rounds over a course of several days, so that everybody got to ask follow-up questions in written form, and the other side got to respond. And so we had quite a bit of back and forth in the form of written questions, and all the judges agreed that it worked. Actually, there were 2 cases that we did that. All the judges agreed that it worked really well in those cases, and that you could follow up in writing and be very specific. So I think it worked pretty well, particularly for en banc.
Do you think the court will do that more often in the future?
No, once we go back to in-person arguments, I don't think so. Although some judges are more likely than others. Over the years, a few judges have asked follow-up questions of the lawyers after argument or before argument, saying, we have questions about this. We want you to either address it now or be prepared to address it argument. But mostly post-submission, if the judges still have questions, some judges don't hesitate to ask the panel, I'd like to send these questions out to the parties. And I think that's a good thing. You shouldn't guess or what they might say. It takes, 15 minutes to write down your questions and have the clerk's office send them to the parties. I think it's very effective.
Yeah, that sounds.
If we have one case on the calendar currently for September's en banc, and it's not clear what we're going to do in that particular case. We haven't decided yet, but it did work well in May for the 2 cases that we had.
Yeah. As a practitioner, I know getting questions afterwards, it would be certainly welcome if, just knowing what the court's concerns were and being able to answer them. I'm going to hit pause for just 1 minute. We're at the last 15 minutes, and I've only got a couple questions so far. So if anyone else has questions, if you could get them in now, that'll be great, and we'll get to them in just a couple minutes. But I'm going to continue myself for just a couple minutes. You sat on both the Supreme Court of Texas and the Fifth Circuit. How are those two jobs different?
In some ways, they're very, very much alike. One obvious distinction is the Supreme Court of Texas does not get criminal matters by and large. It doesn't have criminal jurisdiction, except in juvenile cases where a juvenile has, it's alleged that the juvenile committed a crime, and the question is, are they juvenile delinquent because of that? So those appeals are quasi-criminal and go to the Supreme Court of Texas, but there aren't a lot of those. But on the civil side, the cases are, there obviously you get some federal. We don't get bankruptcy issues by and large at the Supreme Court of Texas or federal tax cases, but you get a very large number of civil cases that either court can decide, and it could go on either court, and it's pretty much the same. One big difference is the Fifth Circuit, of course, is an intermediate court of appeals, and we have to come to a judgment in every single case that's filed. We have to look at all the issues, start with the dispositive issues, but we have to come to a judgment. The Supreme Court of Texas, of course, is a court with discretionary jurisdiction. And I haven't looked at the numbers lately, but when I was there, opinions were issued in like 9 or 10% of the cases that were filed. The rest of the cases, the court just denied review. Didn't necessarily mean that they agreed with what the Court of Appeals had decided, but for whatever reason, they didn't take it to decide on the merits. The Supreme Court of Texas does not consider themselves an error correction court. They try to take cases that will have an impact in more than just that case. So they look at they consider a lot of factors in deciding whether to grant a case. It's also a very different dynamic to work with 8 other colleagues as opposed to 2 on a 3-judge panel. And it's a lot different dynamic having a 9-judge court as opposed to a 17-judge en banc court. That's really kind of unwieldy, frankly, to decide a case with that many judges. So those are some of the differences. And also, I think I always tell the story. When I went to the Fifth Circuit, I took my law clerks from the Supreme Court of Texas. They'd been there a year. They came with me and in a permanent staff attorney. And I didn't say anything their whole year they were there. And at the end of that, I said, how do you compare the briefing and the oral advocacy as between the 2 courts? And every one of them said, it's much better at the Supreme Court of Texas. I think they were somewhat surprised. But the answers as to why should be obvious, because by the time it gets to the Supreme Court of Texas, it's gone through the trial court, typically a court of appeals. It even get to the argument stage at the Supreme Court of Texas or decision stage. It has to, the court has to make a decision that it's a case that's worthy of their consideration. And a lot of times, if the briefing was bad on an issue at the Supreme Court of Texas, the court said, this is an issue we need to decide, but let's wait for the next case because these lawyers aren't really going to help us very much. So they'll wait for the next case to come along. So the advocacy is better because it's been through a winnowing process at the Supreme Court of Texas. And then there's a bar. There are a lot of lawyers who do a lot of Supreme Court arguments that get hired over and over and over again. So they're just like, they're very savvy, they're very experienced, they're very good advocates. Whereas in the Fifth Circuit, as I said, we take all comers. So you get the advocacy ranges from very poor to excellent and everything in between.
So when you get that really important question as a Fifth Circuit judge that the court hasn't written on yet, and the advocacy isn't necessarily what as thorough as you'd like it to be, is there anything that you do to really make sure that you're getting presented as the judge with all that you need to have to decide that issue?
Well, obviously you have you and your law clerks look at every, what have other circuits done? Have they had this issue? Whatever Supreme Court opinions might shed light, you really have to, be careful and thoughtful, and give it a lot of attention on those kinds of issues. And also, another thing, if it's a question of state law, we can certify to Texas, Louisiana, and Mississippi. We can certify state law issues to their Supreme Courts, which we do.
And being on both sides of the certification question, are you more likely to certify a question, because you've been on the Supreme Court of Texas, or does that make you hesitant to certify a question?
I'm probably more inclined than most, I guess. There's some history to that, actually. Long ago, before I was on the Supreme Court of Texas, the Fifth Circuit would certify questions, and sometimes the court wouldn't take them, and the Fifth Circuit frowned upon that. And also, the Supreme Court of Texas's docket is run much more like the U.S. Supreme Court's docket. They start hearing cases in September and quit hearing cases in usually April, early April. So if you certify in March or thereafter, that case isn't going to get heard till the fall, and then it's going to be a little time after that before the Supreme Court gets the opinion out. And some of the Fifth Circuit judges found that lag unacceptable. But when I was on the Supreme Court of Texas, we as a court had a discussion about how we're going to treat certified questions from the Fifth Circuit. And we pretty much agreed if they certify it, we're going to take it. And the court now currently gives that certification high priority. They'll go ahead and move it ahead and add it to their docket so that to try to, they're still not going to hear it in the summer, but they try to expedite it so that the lag isn't so long.
Interesting. Well, I think we're going to get to the questions from the audience now. The first question I see is that one of the members of the audience notes that sometimes they'll see an opinion from the Fifth Circuit that gets very detailed, no matter how cut and dry the issue seems to be. It could be a matter of established law or something like that. But sometimes there'll be a very brief one-page opinion that the court issues. And she has seen this maybe even in some more complex cases. Have you had conversations with the court as a whole about how much reasoning the court should puts in its opinions on various topics?
I don't think the court as a whole has talked about that when we're all together, but on every panel, the panel talks about how long should the opinion be, how much detail do we need, and usually there's a consensus. I mean, and since sometimes the judges go back and their law clerks write this huge opinion, it takes more time to whittle it down so that you'll get a longer opinion than maybe the judge expected or the panel expected. And other times, again, it's a function of if a case is particularly fact-bound, for example, it's important for the parties to be heard, to get their arguments out, and the court hears it and they come to a decision, and there's not that much to write. The parties know what the facts are, particularly if you're affirming what the district court did. The court just decides that there's no need for a really long opinion. When the parties know what the facts are, it doesn't help the jurisprudence to go through all that. So a shorter opinion might be appropriate.
Even on occasion, we see sometimes a per curiam opinion that says for the reasons expressed in the well-written, well-reasoned opinion of the district court's judgment is affirmed. What leads the court to issue that type of opinion?
Well, again, where there's not a lot of new law. The law is pretty well settled, and it just comes down to it's a fact-bound case. And in the district court opinion was well written, and nobody has any problems with the district court opinion. The court just says, we really don't need to spend a lot of time writing an opinion in this case. It's just the panel agrees it.
Not.
Short opinion is adequate.
And then the other question we have from the audience, and this is our last one that I have, so if anyone has one more question, feel free to type it in right now. We've got a couple minutes left. This person wants to know, how do you make the most of the summary of the argument section of the brief?
You know, to me, this is just my personal preference, is it's kind of just give me a straightforward summary, 1, 2, 3, 4, 5 on the issues. I should have gotten summary judgment because, or summary judgment shouldn't have granted because of a fact issue about this. Just very succinctly tell me 1, 2, 3, 4, 5 what it is that requires reversal, or why the district court should be affirmed, or the agency, or whatever forum it happens to have come from. Succinct is better in the summary of the argument, because otherwise it's going to be repetitive when you get into your merits part of the brief.
And when you read a brief, do you go through the summary of the argument first, or do you just dive right into the?
I turn to the index of the brief. Should have an index of what the issues are, and that's, to me, that's just an outline for me. What is this case about? That's the first thing I turn to. And it's, a lot of people just put issue 1, page 10, issue 2, page 15. That doesn't tell me what the case is about. So I think that's you need to think about what is your case about, and use that index or as an outline for your of your brief, so that the judge can turn to it and say, okay, here's what it's about, and here's the issues here are the issues we're gonna have to decide. And you say this, this, and this. Again, succinctly, not in all caps, something that's easy to read. That's helpful to me.
One last question from the audience. What makes a petition for rehearing en banc compelling to you as a judge?
Well, if there's a circuit split, and we're about to, circuit split's a factor. I guess a case that is going to affect more than just the parties, that they're going to be, this issue is a recurring issue, and I think the panel got it wrong, actually. Or it's a big, big issue. I have no idea who's right, but it deserves the court's attention.
Great. Well, I think that'll wrap everything up. I just want to say thank you so much for joining us today, Chief Judge Owen. If everyone was visible on the screen, I'm sure there would be 40, 50 screens full of applause, but I think,
Okay.
really.
Well, thank y'all. I was happy to join it. I'd like to ask them a lot of questions about how they're dealing with all of this and what their practice is like. We're kind of insulated a little bit.
I think we're all doing our best to make it work, but it's been a change in some respects. But yeah, so thank you so much for taking the time out of your busy schedule. We really appreciate it, and I hope you have a good rest of your day, Judge.
Well,
and just one last thing for everyone watching. Someone asked me to read the CLE code again. It's 174090342. And thanks everyone for joining us today, and hope y'all all have a good one.